And we are live. Hello.
Woohoo! Good morning.
Good morning. Well, good afternoon. Because afternoon.
Fair enough. You look like you're looking for something.
I'm just moving things around on my screen and just trying to. There are lots of windows open. So if you want to introduce the episode, go ahead while I do this.
Okay. So, welcome to the Legacy live stream. We are Dahlia Law Group. I am Alicia Holland, one half of Dahlia Law Group. And for today's episode, which is episode 21, we are talking about what exactly is a conservatorship. So, a little bit about who we are. We are lawyers practicing in California in the areas of legacy and estate planning, probate, and litigation in those two areas. And so we come here every week to talk to you, lovely people, to just give you some straightforward tips and advice on various topics that fall within those areas, to try to get you some resources and language so that if you need a lawyer, you will be well equipped to walk into that conversation. Or if you need to try to figure out some ways of trying to do it on your own, that you will be as well equipped as you can to try to know what you're walking into. So, like I said, I am Alicia, one half of Dahlia Law Group. Who
I
are you?
I am Jill Bates Moore. I am the other half of the lawyer team at Dahlia Law Group, and most recent owner of some clear screen real estate. There were a lot of windows all over the place. All over the place. So anyway, how you doing?
Well, I was going to ask you that question.
Well, now I've asked you. So how you doing?
Fine. I am all right. Got my walk in this morning. Got up before walking time so that I could get it in where I did not feel like a foggy mole. Because when I tried that, I felt like a foggy mole for the entirety of the day, which did not feel good. So it's good.
Gotcha.
And I have my Halloween socks on this week because Halloween is coming, so I gotta wear my holiday socks.
I like Halloween. I just I like it. It feels like Christmas without the pressure.
I've been enjoying the Halloween decorations.
Yes.
So I got to see some fun ones on my walk. Somebody had little doggy skeletons decorating their front yard. So there's like a little weenie dog skeleton and something that's like about Cocker Spaniel sized skeleton hanging out in the front yard.
Oh, huh.
And it's one of those like you see it and do a double take, like, what? Oh, Halloween. Okay, got it.
Yeah, I still feel like I still think the SPCA might need to be involved, but okay. Um, yeah, I read this article where a woman, I don't remember what city she was in, but she decided to hack trick or treating. And so she, bless her heart, she went and got the trick or treat candy and attached the candy to popsicle sticks. She would tape the individual candy packages, like your Reese's peanut butter cups or little bags of Skittles or whatever, and she taped those to popsicle sticks and stuck the sticks in her front yard. Or her plan is to stick the sticks in her front yard on Halloween, so
Like
that
candy harvesting.
so that kids can do their trick or treating social distance style, since nobody will be, she doesn't anticipate anybody will feel safe knocking on the door and, handing out candy the usual way. So
That's
apparently,
awesome.
yeah, apparently her neighbors saw her outside testing the theory to see how, because apparently like it's a whole thing to get the stick to
Yeah.
stick,
Yeah.
and whatever. And the neighbors were like, we want in, and so now everybody on this, a bunch of people on this block are sticking sticks of candy
That's
attached
awesome.
to them to their yard. I thought it was cute. I
That
thought
is
it was
really
cute.
cute. Yeah, it makes me think of when I was a kid, they had this carnival. I just remember it at my elementary school, and I don't remember like why we did it, but I know it was like once a year and it was a big deal. And so you got little tickets and things, and it must have been around Halloween time
Okay.
because I remember one of the things like you could spend your little tickets on was going and getting bandaged up with different things, so that you could be like kind of mummified. But then
Oh,
you could
okay.
pay an extra ticket if you wanted your bandage to be bloody. So that's why I'm thinking like it must have been
Oh,
around a Halloween type of thing.
I
But I
see.
also remember there'd be the little kiddie pool and ducks. And so you could go duck hunting, and the different ducks had numbers written on the bottom. And depending on what number you got on the bottom of your duck, said how many tickets you won for that one.
But what do ducks have to do
But
with
why
Halloween,
this is
though?
coming to nothing. That's why I'm saying I can't remember. Like, I just remember you would go to all the different classrooms, would have different games set up. So think like a fair with all the different carnival and fair games, but it was in our elementary school, and each classroom was a different little game thing. And you just got to run around for it was like on a Friday night and play all these games and win all these
Little
prizes
kids running
at the
amok.
elementary school.
Just running amok.
Right? And so, like, the bandaging was just one of the things that you could spend some of your little tickets on. But one of the ones was just making this come up. I'm like, ooh, this would be perfect for social distance Halloween. Was you got to go fishing. And so it would be, I know it was just like a big white bed sheet that had a holes cut into it. And so you would like take your little ticket and stick it in the little hole in the sheet. And then when you felt the little tug on it and pulled it back, then your little prize was at the end of your little fishing rod. And so you could do social distance trick or treating with the little fishing rod.
I really hope that you decorate your house this year and that you do some of these things because you have a lot of thoughts about this. I think you should activate them.
That's not even a thought, that's a memory. It's part of the Grissom Elementary School legacy, like the chili and the cinnamon rolls.
Well, legacies aren't meant to be kept for yourself. So, Nikki is here. Hey, Nikki. Thanks for joining us. Thanks for being here. Today we are talking about conservatorships. I'm okay. I got my ballot filled out yesterday and got that in the mail, and I was just like, mm. It's so much. It's not as bad as last time. Last time I remember 2016. That no, it was even more recent than that. The midterm elections.
The 2018
Yeah,
ballot.
the 2018 ballot was that thing was. It felt like it was as thick as a dictionary, and
Trying to figure out what to do with all those
trying
cards.
to research. Well, and then trying to research all of the measures and figuring out what was what. Because anyway, that is done and it is in the mail, and I have gotten my confirmation from the tracker that that my ballot is on its way to to be counted.
Excellent.
So all of that is I'm glad that that's done. Where's my I voted sticker? It's around here
Yeah,
somewhere.
where's your sticker?
I know, right? So
Yeah,
anyway,
that is pretty cool. At my post office, they even have converted one of the drop slots in the building, and it says ballots only on that one.
gotcha, gotcha. Yeah. So
They're like, you ain't gonna have us out here looking like a booger talking about we ain't delivering ballots. Bet.
yeah, well, that also makes a whole lot of sense for safety's sake, I mean, the safety of the ballots, because there have been some reports, and you know how some of this stuff gets really overblown, but sometimes, these things do happen. But I have seen a couple of reports where ballot collection boxes, somebody decided to set one on fire, and I was like, really? We're just gonna burn it with fire. That's what we're gonna do.
Yeah, I saw one of those, and one that somebody put out some fake ones. So there have been I've seen them on Instagram a lot for our county, of how to verify that this is a legitimate ballot drop box, and you can look up the location so that you can verify that there is in fact supposed to be one here. So if it shows up in your front yard overnight, that's probably not legit.
Yeah, I think that it's important to be careful about just about being overly suspicious as well, because I do think that every single election cycle, no matter who's running, you can fight me in the comments. Actually, go fight somebody else. I'm not interested. Every single election cycle, no matter who is running, there is some disinformation. There is that just kind of happens. It is worse. It does feel worse right now. But there are always some folks with some agenda for some thing, yeah, right, that aren't interested in having free and fair elections. And so I think being careful about being overly swayed by some of these reports is important as well. Lisa's here.
Hey, Lisa.
Hey, Lisa. She says 21 episodes. Y'all are legal now.
We can drink.
Get it?
Yeah, we can drink.
Oh, goodness. All right. So let's talk about...
Should have put something stronger than sparkling water in my little cup today.
Oh, okay. Oh.
I mean, since we 21 and all.
So listen, today we're talking about conservatorships, and specifically what we're talking about regarding conservatorships is some tips and tricks for how to get your conservatorship application through and approved, sort of how to set yourself up for success on that first application. So by the end of the conversation, what we are hoping you will walk away with is a reminder of what conservatorship is. And we have a whole earlier episode on nominating conservators and talking about what a conservatorship is. So please reference that and pass that along. But a reminder about what conservatorship is, an understanding of what conservators do. The conservator is the person who is in charge. The conservatee is the one who needs the conservator to be in charge. An overview of what the conservatorship procedure steps are, just at a sort of a high level, and then tips for identifying when a conservatorship might be needed, gathering information to support the conservatorship petition, successfully completing the application process, the court application process and the hearing process, and then complying with the ongoing conservatorship requirements. So this episode is chock full. We are going to roll through fairly quickly. And so it is going to be important today as ever, but maybe even more important today, that you ask your questions and stop us if you need us to stop, or to clarify where you need us to clarify. That is what we are here for. So I'm cool with starting with what a conservatorship is, and then we can take it from there.
Let's do it.
All right. So a conservatorship is a court process, and it does two things. Two really important things. One is a conservatorship removes an adult person's ability to make certain decisions for themselves when they don't have capacity to do those things, to make those decisions safely and responsibly. So the first thing that a conservatorship does is actually strips away power for an adult person who would otherwise be able to exercise all of their adult rights, it strips away power for an adult person to act on their own behalf in some significant ways. Then it puts someone else in charge of making those decisions for that person with court oversight. So it is a court process that takes away power of the person, that gives power to the substitute, or to the stand-in, and the court continues to oversee that process and that relationship. Some of you are going to have questions because you're going to remember that we talked about durable power of attorney. And one question I'm going to anticipate right now is somebody may ask, what is the difference? What is the difference between these two things? Because they can sound very similar to one another. And one critical difference is that under a durable power of attorney, the person who has given power for the agent to act still retains their own right to act, right? So there's no court order divesting them of power or removing their personal power. Whereas with the conservatorship, the court is taking away power for that incapacitated person to act. So a person who is subject to conservatorship is not responsible, for example, for contracts that they might enter into, because when a conservatorship is in place, that person's power to enter into a legally binding contract is removed, right? So we only have one actor, and that person is the conservator. With the durable power of attorney is potentially two actors, right? The person who has given the power under the power of attorney and the agent. So a conservatorship can cover personal decisions like where I live, who my doctors are, whether I go to what doctor's appointments or not, right? It can also cover money or asset decisions, or it can cover both of those things. So, Alicia, do you want to just hit the highlights on the main stages? Just identify those before we deep dive into them.
Sure thing. So the main stages of a conservatorship, and these are kind of the main stages on the timeline of how do we get from we need to help to actually having the legal papers that you can to do that legally. So the first one is confirming and deciding if a conservatorship is needed. Then we're going to do some filing, meaning filing at the courthouse, because we said it's a court process. Once the filing is in place, that kicks off an investigation and assessment period, which then can lead to the appointment, which is appointment as a conservator. And then once you're appointed, we talked about, Jill just mentioned that the court is going to continue seeing through this process. And so that means once you're appointed, that's not the end as far as the job goes. Then there is some initial reporting and accounting, kind of the get you started stuff once the appointment is in place. And then there are some ongoing duties, because that conservatorship is going to stay in place until one of about 3 different things happens. So hitting that first one of deciding if a conservatorship is needed, number one is assessing the incapacity. So we're talking about conservatorship, and often when a conservatorship is coming up, it's that something has gone on, or we can see it, and we need to figure out, we need to support this person. So very often conservatorships are dealing with, just by nature of what they do, it's very often dealing with people that are older, that have some cognitive impairment that has come up, like dementia diagnosis or Alzheimer's diagnosis, or they are headed down that path even if the diagnosis hasn't happened, but you're starting to see those impairments, and we got to figure out some ways that we can help mama or daddy do ABC, XYZ is often where this comes up. And so with a conservatorship, thinking about assessing that incapacity and why there is so much process, and we don't just say, we just run to the courthouse and do it, is because of that part that Jill talked about, the 2 parts of that court process that happened. It is drastic when we go to a conservatorship, because it is stripping a person of their rights. And so because of that, the courts are very cautious and want to make sure that this is a necessary step before they just go do it. Because while in our minds, we think of it as I am just helping mom or dad do this, so it's more of a partnership process. In actuality, what happens when we do a conservatorship is the court is stripping them of their legal capacity to do certain things, like entering into contracts or authorizing their own medical treatments. Depending on the state you're in, it might strip you of your right to vote, since we're talking about elections, even the right to marry, different things. And so when you think about all of these rights that we think of as fundamental rights for a person, and with a conservatorship, when that person is declared incapacitated, that is going to be stripped away from them. So the first question is actually assessing that person's capacity and seeing, is this the best way to deal with it? So how do we do that? You're going to this is where you have the family huddle up for all the people that have been dealing with this person that you think might need the help, to just kind of gather the facts from everybody and what they've been seeing and experiencing with communications with the person that you're dealing with. So is it they're forgetting things, or you keep having to repeat things for them? You notice that they keep losing their keys, or there's been a change in their personality, because sometimes that can very often happen where it's anger is actually masking the impairment that's coming up. And so it's coming out like you're just in a bad mood or lashing out at everybody, but there might be something deeper to it. And so doing that fact gathering.
Yeah,
If you can.
some conditions actually come with
Yeah.
behavioral disturbances as part of the diagnosis, right? It's actually part of the underlying health condition as well. So it could be a mask, but it could also be it can also be an exemplification of what the underlying condition is.
Yeah, 100%. And so another place to talk to about this, and this one gets a little tricky because sometimes you may not always have access, but talking to the doctor that is seeing that person. So even if it's let me go to the doctor with you, and just kind of being in the room and asking the question of the doctor or the nurse, kind of what they're seeing, if they've seen changes in that behavior, because very often the doctor can see it and will want to assist, but it's beyond the scope of what they can do to just step in. But if you ask the right questions, or if the doctor has been seeing this decline, they will often help you with being an advocate for this person, because they want to make sure that their patient is safe.
Right. And this conversation is really important. It's really important to have it as soon as you see something going on. I know that, so I will just say, as part of my family cultural experience, there is a lot of elder respect. And so the way that we approach granny, or or grandpa or something like that, it's going to be with it's going to be at a respectful angle. It is going to include, as a reflex, a good bit of deference to what granny or grandpa, for example, sorry, I was about to pull my curtains down. It was about to be a whole embarrassing situation. Somehow or another, I got the curtains lodged under my under my chair wheels, and yeah, it was all about to come tumbling down.
It was good to be a thing.
You know what? This is a life in progress. Welcome.
That is sprinkles.
But this is a place to actually push on that deference, and here's why. The conservatorship is legally, and as a matter of human experience, a pretty extreme thing. And so if you can avoid it, then you want to avoid it, right? And if it is necessary, you want to have the most limited amount of powers that are appropriate for the situation. One of the ways, and we'll talk about this more specifically later, one of the ways to potentially avoid a conservatorship is to have a durable power of attorney and healthcare powers of attorney. And just because somebody has a diagnosis of a condition that will ultimately cause a cognitive impairment or has already caused some level of cognitive impairment does not necessarily mean that they have lost capacity to make those powers of attorney or healthcare directives and that sort of thing. So talking with the family and talking with the doctors is really important for you to be able to assess where you are, because if you get it early enough, then there's a potential that if you get the right tools in place early enough, then there's a potential that you might be able to avoid this conservatorship altogether.
Yeah, 100%. And that can be really helpful for just kind of the ongoingness of it all. Because, like we mentioned with the conservatorship, once the court is in, they are in. So when they have had to go through the drastic step of stripping somebody's capacity, the court sees that as, because we have now taken jurisdiction over this person and their well-being, we have an obligation to continue making sure that this is the right setup and fit. And so, as we've talked about in many other episodes, when you go to court, that always comes with a bill. And so all of that ongoing work also comes with bills and expenses. And so if you can catch this early and you're talking to the doctor, and you can ask the doctor, if you have gotten the doctor to engage in a conversation about this, then you get to ask the question, do they have capacity to do a power of attorney? And it might even look like we go in for an exam, and if the doctor examines them and says, yes, they understand and can appreciate what's happening here, you have the form there with you at the doctor and fill it out right then. Is this what you want, mama, daddy, auntie, uncle person? Like, who do you want to be in charge and who is your alternate, and all these things, and having them sign off on it. And then you have the bolster of that doctor's exam note for that same day that this person had capacity to do it. And just by getting in early, that's done. You have what you need to support that person, and you get to avoid this whole conservatorship court process.
Yeah. Yeah, it's a really important it's an important early conversation to have for all of those reasons. Like I said, culturally, there are so many of us who really venerate our elder loved ones, and yeah, right? Like and there is a way to have this conversation that is also completely respectful of that. So don't, I guess my encouragement is to remember that love sometimes requires proactive action. And sometimes it requires pressing into a soft place. And so, or into a tender place. And that's okay. You can have that conversation in a care giving and care expressing way. Ask me how I know. All right. Hey, Danielle. Thanks for being here.
Hey, Danielle.
Hey. So the next thing is to just know that there is not going to be a conservatorship. A conservatorship's not going to be needed if you've assessed that incapacity and found that there is no incapacity, right? Maybe grandpa is just ornery. Right? Maybe grandpa has complete capacity to function in his life. He just doesn't like you.
Yeah. So, and just because you don't like the choices
right,
that grandpa's making doesn't necessarily mean he is incapacitated.
Exactly. So there's that. Also, we talked about,
I'm laughing because we all have these people and we have met them. It's like, oh Lord.
Yeah, 100%. It's like he's fine. He just doesn't like you.
Yeah.
Or he's fine, and yes, that is his new partner. Right?
Who's you out and he meant it too.
Right, who's 40 years younger than him. But that does not mean that he is incapacitated. Just because Granny got her groove back doesn't mean that she is incapacitated, right? That might be grown folks' business. So, so if there is no incapacity, then no conservatorship. If there is an effective, durable power of attorney, remember durable, remember what that means. If you don't, go back to the episode where we talked about that. If there is an effective, durable power of attorney that appoints an agent who is qualified and willing to serve, then in all likelihood, you're not going to have a conservatorship. Sometimes, maybe, but most, I would say 8 out of 10 times, no. Similarly, if there is an effective Health Care Directive that appoints a healthcare agent who is qualified and willing to serve, then you're not likely to have or to need a conservatorship that covers that area of your loved one's life.
Yeah. And then just as a note, this is something that we're not going to spend a bunch of time on today, but it's a thing to know. In certain places, like in California, it is something that we have that's called a limited conservatorship. And a limited conservatorship is a special carve out that we have, because we have people that have full capacity that can handle and manage their own affairs. And then this conservatorship that we've just talked about, and we're telling you that it's such an extreme and it's a deprivation of rights. There are a group in kind of the in-between that fall into this category of limited conservatorship. And a limited conservatorship is used when you have somebody that has some things that they might need support with, but they don't rise to the level of extreme that they need the full conservatorship. So here it is when you have particular diagnoses. One of them is autism, that if you are receiving services through a particular state agency that assist with that, you might have a limited conservatorship in place. And what they've done is they categorize kind of 17 areas in that limited conservatorship and specify which ones the conservator has the power to act on. So it might only be about assisting with financial decisions, but not necessarily restricting your movements or who you can associate with, or the right to marry, the right to vote, different things like that. And so that limited conservatorship is out there. And one of the things about that is if you have a young person who is set until they hit 17 and 354 days, then or 364 days, then parent gets to make those decisions. But on that 18th birthday, parent no longer has rights to do that.
Right.
And so if we are in a situation where a limited conservatorship is needed, it is one that you are allowed to file before the 18th birthday so that there's no gap in time there, so that it goes into effect on the 18th birthday of that person, and the parent or whomever is appointed as that conservator can continue supporting that young person.
Exactly. And Lisa is in the comments, being Petty Betty, talking about if your background fell all the way down, it would have been a mess. But you know what? In fairness, these are curtains on a window. This is a painted wall, so this is not going to fall down unless there's other problems. But this was about to come crashing down on my head.
There's a commercial out right now, just in the life of, like, we're all doing the Zoom things, and this man comes and he's got on his cute little polo shirt, but he's in his tighty whities and socks, and he comes out to the patio and his wife is looking at him like, I'm about to kill you. And their friends are sitting there and he's like, oh, it's not a Zoom thing. Like, he knew they were having the cocktail date. And so Lisa talking about the wall crashing down, I'm just thinking, can you imagine you're the person behind the wall and you're like, oh, I wasn't expecting that. I thought I was good back here. That could go down bad. So I'm glad you got the wall, and it would just be the curtains if it came to that.
It can happen to the best of us. I told you yesterday, I almost joined a business meeting on Zoom without. Anyway, it was just almost bad. Just know that. Okay. All right. So the next step is like the next sort of topic bucket, right, in the steps to getting a conservatorship in place is filing for the conservatorship. Remember, this is a court process. Everything that's going to happen in a court process is going to involve the filing of paperworks and the paying of fees. So the first step in filing is actually, before you even touch a piece of paper, it is to decide which type of conservatorship you need to apply for or your loved one needs to have in place. And that can be a conservatorship of their estate, right? And remember, estate means money, stuff, right? Property, things that are not human. Or the conservatorship can be over the human decisions, right? Like where I live, what my social decisions are, who my doctors are, and that sort of thing. Or it could be both. Okay. But know that the court is going to lean toward depriving the conservatee, who is the person who needs the help, the person who has the incapacity. The court is going to lean toward depriving the conservatee of the fewest amount of rights possible. So, for example, if somebody can manage their personal care needs, so for example, they can live on their own, right? Even if they need help to do that, right? So even if they need some assisted living care or in-home health help or that sort of thing, if they can manage their personal care needs sufficiently and safely, even with help, but they have a cognitive incapacity that makes it unsafe for them to handle their financial affairs. Right. We helped a client who had a loved one who would just indiscriminately take strangers to her bank and pull out money and give the money to the strangers, not knowing who those people were, or why. Like she would sometimes sit out on a local, just like in a local park bench, enjoying the sunshine, and might encounter a stranger, take the stranger to the bank, get people money. So that person, she was able to live at some time she was able to live on her own, but if she were able to manage her personal needs sufficiently, that conduct in and of itself the financial conduct in and of itself would trigger someone who loved her, and did in fact trigger someone who loved her to say, hey, hey, something, she needs some help. And so a conservatorship of her estate, right, might be appropriate. And this is a place where I say might, because always circumspect with these hard absolutes. But this is a situation where even if there were a durable power of attorney, a conservatorship might actually still be appropriate in order to shield that loved one from the consequences of making a contract or of giving the money away, or something like that, right? Restricting her access to certain bank accounts and that sort of thing, which under a durable power of attorney, you cannot restrict someone's access necessarily to their own things. So decide what type of conservatorship you're going to be applying for. And then, do you want me to do this part, or do you want to just kind of Wimbledon?
Oh, you said Wimbledon.
I did.
I thought you said Windowden, and I was like, I don't know what that word means. So I don't know how to vote.
I'll do this part. Never mind. So the next step would be to start working with the potential conservatees, your loved one who has the incapacity, to start working with their doctors or healthcare team. We already started talking about the reason for this earlier, so I'm not going to go all the way back through all of that. Just note some practical things here. One, the court is going to require a medical diagnosis. If there is a medical diagnosis, they are going to require it. They are going to require a declaration under penalty of perjury, some sort of sworn testimony from an actual doctor who is actually qualified to make that diagnosis. Okay, so these diagnoses frequently require cognitive testing or other testing. Getting appointments can take a while, and then doctors take a while to complete paperwork like this. Courts usually have their own forms that, or at least in California, there are mandatory forms, right? There are court forms that are designated for mandatory use by doctors. You usually have to go through the medical secretary's office. So do not call up there acting a fool with those people. They can help you or they can not. And while you do not have to lick anybody's boots because that is not required, you also do not need to make this harder for yourself than it has to be. So
already got a road to hoe here. So
exactly.
Don't add stuff to it.
So I would suggest that you know what those forms are. Go ahead and download them. Get the appointment on the calendar and then take the forms with you to the appointment so that the doctor can either complete them as they are doing the diagnostic testing, or you can get the documents in the doctor's hand and they can and then you can follow up directly with them about getting the signature. The doctors don't want to touch this more times than they absolutely have to, right? Like doing court declarations is not a doctor's job, is not the primary care doctor's job or treating doctor's job. So make it easy for them.
Yeah. Now, another, just a quick note on that, another reason to have the form and take it with you is so that whenever the doctor does it, whether it's at your appointment or later, they have had a chance to see it so that while they have that person in front of them, if there is a portion that gets asked about in the form that's something that they don't normally do as part of an exam, they will be able to do all of the parts or to see what specifically are they going to ask me so that I can competently answer those questions.
Yep. Absolutely. The next thing to be thinking about, or the next thing to do, is to decide who should apply to be the conservator. So this is another time where you're going to be looking for your loved one's paperworks. That's the first thing you're going to do. Look for the paperworks. Because if your loved one has a legacy and estate plan or any element, any tool that is within a legacy and estate plan completed, there might be a nomination of who the conservator should be, who they want the conservator to be in that plan. So look for that. Also, anytime, at least in the state of California, anytime someone is applying to be the conservator of someone's estate, anytime there is going to be a court order putting someone in charge of someone else's money or property, the court is likely to require a bond. A bond is a type of insurance that basically protects that other person's stuff in case the person who the court puts in charge either makes a mistake or steals or destroys or damages or whatever the stuff, in case the conservator does not carry out their duty the way they're supposed to. And so the nomination of conservator can waive that bond requirement. It is possible for that to happen. If it's not waived, then that bond is going to be required.
Yeah.
Full stop. Expect that. And so who should apply to be the conservator is somebody who should be bondable, right? In order to qualify for a bond, there's likely to be some level of credit or public records check or both. It may not be like a deep dive, we're trying to qualify you for a mortgage type of credit check, but they're likely to do that. They're likely to do at least a surface level credit check and a public records check. So I would suggest contacting a bond company before you submit the paperwork to the court. I know It sounds a little backwards, but here's the deal. If the bond company pre approves or pre authorizes the bond for the person who is going to be applying to be conservator, then all you have to do when, when you make that filing or the court signs off on the order after you file is go ahead and file the bond, right? But if the bond company will not issue a bond, then you need to find somebody else to be the conservator, because it is possible that you could go through this entire process. All the paperwork's with the court, all the filing fees, all of that stuff. If the bond cannot be issued, then you have to start over.
Back at the beginning.
Back at the beginning with the paperwork, with the fees, and all of that stuff. So actually check that ahead of time.
Yeah.
That's important. Yeah, it really is. I'm gonna update the notes in the stream, and Alicia is gonna start talking to you about accounting and notices.
Yes. So in that filing process, some of the things that you're going to do, some of these things are about getting you set up for some things that are going to come later in the process. So this next one is one of those. And so setting up your accounting tracker right away. And part of that is about the later, but part of that might actually come up immediately. So if we know we need to help, but we don't have access to the funds or not sure what they are, and so maybe I'm going to front the money for the application fee for the court process, having appropriate records is how I'm going to be able to get reimbursed for that. And so if you're going to do this job, because you are going to have so many ongoing responsibilities, go ahead and set up your accounting system at this point of keeping track of it, whether it's you're using your person's money or you're using your own money to cover bills and expenses, having your system set up for how you're going to do that, because what you will see is when it comes to this, and this is especially we're talking about when you're doing the conservatorship of the estate, you are managing somebody else's money. So much accounting and reporting is required that the earliest possible time that you can get a hold of what is the system, keeping track and being very diligent about that is going to make your life a whole lot easier all the way through this process. So go ahead and get started with that now.
Right.
Then next thing up is the notice process. And so this is a due process issue. And so whenever we are taking something away in the court process, there are some folks that are going to be entitled to notice to speak on this issue. And so knowing, just thinking about kind of the high level of what we're doing here, the notices are a thing that can honestly hang people up, because the court everybody can be in agreement. This is a thing. This is what we need. But if you've not done the right check marks on the notices for due process issues, screeching halt in the process. And it's going to be delayed until we can say that we have given notice to the people that it's required for. So before you even start the filing process, because once you file the paper, a hearing is going to get set, and that's going to start the clock on some of these things. And depending on the level of emergency that is in play here for how quickly we need to get support for this person, that clock might be real short. And so having as much of the information as possible that you're going to need for the notice process before you get to filing one is just going to make it smoother. So we're going to identify the people who need to get notified and their contact information. So that's going to be who's that primary care doctor that we're going to go to for the assessment, because we might even be listing them in the petition so the court knows who we're going to be going to there. If the exam has already been done and there's some sort of letter, so sometimes a doctor might write a letter saying, in my medical opinion, this person does not have capacity to manage their own personal affairs, and they sign it and it's on the doctor's letterhead. That is not going to be enough for the court's full-on assessment, but it helps bolster your petition if you already have that letter and can attach it to the back, particularly if you're making some sort of emergency, like we need help right now filing. They're going to be looking for something like that even some diagnostic has been done. There are going to be certain family members that are going to be entitled to notice. And so identifying who those people are and kind of the levels of, I'll call it the levels of generation that it is. So, like in California, for instance, it's within 2 degrees of the person who we're applying for. So, if that person has children and grandchildren, then we've got to notify all of those people. So, even if they have 47 grandchildren, then we are going to have to send this to all 47 of them grandchildren. And so identifying what are legal names for these people and gathering the addresses for them, because number one, you're going to have to list them all in the petition, and then you're going to have to send the notice to them. So do your best information gathering on that. Then once you get it filed, at the time when, so here what happens is, if we actually took it to the courthouse, now we can't take it into the courthouse building, but as soon as the court accepts it for filing and stamps that sucker filed and gives it a case number, they are also going to assign a hearing date. As soon as you have that hearing date, you can go ahead and start serving these notices. You can't, there's no such thing as serving it too early. There is such a thing as serving it too late. And so the way that notice process works is you start from the hearing date and are going to count backwards. And there are going to be a certain number of days in advance of the hearing that you must have a person served by. So if it's something that, say, for instance, it says 15 days before the hearing, you don't have to wait until the 15th day before the hearing. So if you get it and it's 4 months out, you can still go ahead and serve that notice right now for that hearing date. So you can even take your stamped envelopes that are already addressed for all these people that you know you're going to need to give notice to. You can take your envelopes with you when you go to the courthouse so that as soon as they give you that hearing date, you can fill it in. There's always a copy shop near a courthouse, and so you can run all your little copies, stuff your little envelopes, and drop it in the mailbox and circle right around back into the line. Because the other thing you're going to have to do with your notices is once you've served the people, the court needs proof of that. And so the document that you use for that is called a proof of service. And so with that proof of service, it has to get filed. And that's how the court can check the boxes that, yes, all the people that needed to be notified have been. And you want to have that on file well in advance of your hearing date. And so if your brain works like mine, if I have it and it's done, it's better to just go ahead and do it now instead of, oh, I'll remember to do that later. Because what I don't want is to show up at the hearing knowing that I've done it, but because I haven't filed my proof of service or the court hasn't had a chance to see it, we can't go forward with my hearing because they have to verify that I have in fact served all 47 of the grandchildren.
Yep. That's actually a really big deal. It doesn't, because it is not a difficult thing to do, it doesn't always land on people as important as it is. And because frequently the people that you would have to give notice to are people that you're already in conversation with, especially if you've done some of the things that we've recommended about having the family meeting and having the conversation early about what to do about granny or what to do about grandpa. So it doesn't always stand out as being that important because they already know, right? They already know, they already agree. Everybody is in it together. But this is not the notice is not strictly to let them know what's going on or to let them know what they already know. It's actually a legal requirement and it's got to be done before any orders can issue. So just take those stamped envelopes with you to the courthouse and drop them in the mailbox while you're there. There is always a postal mailbox at a courthouse. If it's not in the court building, it's usually right on the sidewalk outside.
And in a lot of places, the post office is right next door, or on the same block.
Well, actually, in one of the courthouses in Oakland is actually in the post office building. So, or at least it used to be. They're changing some things now. So,
it's downstairs.
Yeah. So, let's see. The next step is going to be investigation and assessment. This part is not going to be a part that the conservator does, but the conservator can actually really help this to go smoothly and to go well. So you're going to be filing an application to be the conservator. You're going to say all the reasons. The doctor is going to say all the reasons. You're going to give all the notices and all of that stuff. And the court is going to say, thank you for this. We will send our own people and see for ourselves. They will literally appoint, in California, this office is called the Office of the Court Investigator. And so they will send an investigator out to the place where the conservatee lives. The investigator will look at the living situation. They might talk to doctors. They might talk to neighbors. They might think of this as a home visit, right? If you've ever had any occasion to deal with child protective services or adult protective services or any type of human protective services office, this is very much like that. And the court investigator will coordinate with the conservatee's attorney. Conservatees are entitled to be represented in the state of California. So a lawyer, if they don't have a private lawyer, then one will be appointed for them. And so that will all get coordinated. Help them. This is a necessary part of this process. So actually help them do it. If there's something that they need to know, like, one of the ways that my loved one's health condition presents is there is paranoia. So you just showing up and ringing the doorbell or knocking on the door is not going to get a good response. My loved one needs to see somebody that they know before they are going to open that door. That person, if you need that person to step aside or wait in the car while you do the visit or whatever, then fine, whatever you need them to know, right, in order to get access. The other thing that the court investigator is gonna do is to they're gonna issue a report, and that report is going to come up before the hearing. And you are going to be entitled to a copy of that report. When you get it, two, look at it. Because if there are any issues that show up in that report, then you want to make sure that you're able to deal with them ahead of the hearing, before the hearing if you can. But if you can't, then at least be ready to deal with them at the hearing. Note that court investigators come with a fee. That fee in California has to be paid before the court order approving the conservatorship will be issued. That fee in our state, or at least in the county where we mostly practice, no, actually it's a statewide fee. It's a minimum of $800. So be prepared to pay that fee, or make sure that the conservatee has funds that are set aside to pay that fee. And if not, then be ready to apply for a fee waiver so that you can address those things at the hearing. So this is one of those places where the person who has applied to be the conservator they're not doing the investigation, but they sure can help that part of the process along. And even if they're not helping it along, they can prevent it from being a thing that kind of gums up the process.
Yeah. And this is in one of our tips of setting yourself up well in this part of the process. Be truthful in your application. Mm-hmm. It never works out well because that investigator, as we said, they're investigating the person that's going to be the conservator to make sure that this is an appropriate person to be put in charge of another person. Yeah. And so when you do the petition process, there are going to be some background questions that are part of that process, and it's asking about you, like, have you ever been convicted of this, that, or the other, and it might be certain sorts of things, or have you been removed for certain things, different questions like that. And even if you're on the fence about it, and then obviously with these types of things where it's if yes, then give an explanation. Like if you're on the fence, and even if you don't have all the details to remember it, put it on the form. and fill it in, because what you don't want to happen is you go through this process and you've paid the investigator fee, the filing and everything, and something like that comes up, and it was that you did not disclose it and the investigator found it. And so then you have to find a new person and start back over with new filing fees and everything. So set yourself up well by giving all the information that you need to on the initial filing.
Yeah, that's a really, really important point, Alicia. Thank you for catching that and for bringing it up, because not everything is disqualifying, right? They will ask about felony convictions. They will ask about um, terminations for jobs for dishonesty and and that sort of stuff. They will ask those things, but those are not necessarily disqualifying yes answers. So well, but not disclosing those things is disqualifying. So two things about this. One, what Alicia already said. Just tell just tell the truth about the stuff. Okay, so there is that. And know that if the investigator's report comes back and says, I got concerns about this person being the conservator, they didn't tell the truth on this background screening. We found something that was different than what they found. And the court says, no, you're not going to be able to be the conservator. Here's the deal. You do not get to just substitute another person on that same application. You literally have to start over. And what's happening in the meantime is your loved one actually doesn't have the help that they need. That's what's happening, in addition to having to spend the money and time all over again. The second thing is the questions, the background questions are in the forms. They're in the forms. Mm-hmm. So when you're looking at when you're going back, when you're in that earlier step of deciding who should be the conservator, look at those questions. And if you have any concerns about those background questions, and it is concern enough that makes you think, I don't think they're going to appoint me, then go ahead and consider somebody else to apply to be the conservator. So we are just at our hour now. So we are finishing up our lunch hour, and we still have a decent enough amount of thoughts to go through. And I don't want to rush through those thoughts. I think it's valuable enough information to actually just give it its due. So what do you think about continuing this conversation next week, Alicia? I know that's not what we planned for, but are you open to that?
I am open to a continuation. I am not open to it being next week. It will be in 2 weeks.
Oh, yeah.
Next week is a special episode.
Yeah.
And that we are keeping.
Yes, we are. Okay. So
I was paying attention.
Y'all, these elections and this stuff and all of it. Next week is the day after Election Day. One thing to know about us is that we have closed the Dahlia Law Group offices for November 3rd and November 4th. November 3rd so that everybody can vote without having to worry about work. We just don't think that that's something that people should have to worry about. And as small as our team is, that is true for us as well as everybody else. So we're closed on November 3rd for voting. And on November 4th, we are closed for recovery because we tied, y'all. These elections and all of the stuff have worn us out. And so we will not be open on November 4th. But because November 4th is a Wednesday, we decided to go ahead and have the live stream that day. But it is going to be a bit of a different live stream. Instead of our legal topics, we are going to be talking about taking care of ourselves as human beings, right? In such a time as this. So it's going to be a looser, more, well, I don't know what's looser for us. We're pretty loose, but anyway,
But we
more,
want you to join us because
yeah,
we want you to take care of you too.
exactly,
So we're holding space for us to take care of each other.
absolutely. Um, so
But in 2 weeks we can talk about this again.
yeah, so we can pick up with the rest of this investigation stuff. We'll pick up with investigations and go on from there on November, what is that, 11th? Yeah, the following Wednesday. So that's what we'll
That's
do.
That is some impressive calendar knowledge. I'm like November something. Hell if I know.
Yeah, friend, we're gonna take that break day because 7 and 4 is gonna be 11 every single time you think about it. So anyhow, thank you all for your flexibility and your adaptability on today. We will do a quick summary and recap when we revisit this topic on November 11th. And we will look forward to seeing you here on Wednesday, where we're just gonna sit around and be of good care with ourselves and with each other. We will not be talking about the election. We will not be talking about work because our office is closed that day. We are not working. We will instead be talking about the caregiving and loving and soft stuff that we rely on and that we're curious about, that we're interested in, and we hope that you'll join us for that. All right, y'all. Have a great Wednesday. If you need to reach us in the meantime, where can they find us, Alicia?
Instagram at Dahlia Law Group. Internet at DahliaLawGroup.com. Email DLG at DahliaLawGroup.com. Or by phone, which is on the website at www.dahlialawgroup.com.
Thank you. Thanks, y'all. We'll see you next week.